Get ready for the new U.S. immigration reform. I'm getting several questions from people. Attorney, what can I do to start preparing for the new parole process that's about to begin? So on Tuesday, June 18, 2024, the DHS, Department of Homeland Security, announced a key step toward fulfilling President Biden's commitment to promoting family unity within the U.S. immigration system. So DHS is establishing a new process, a new parole in place process, and they're going to adjudicate requests or applications for some non-citizen spouses of U.S. citizens who have been continuously present in the U.S. without admission or parole for 10 years or more. They have no disqualifying criminal convictions. They don't pose a threat to society. They're not a threat to public safety. They pass vetting. They're otherwise admissible. They're eligible to apply for adjustments of status, and they merit a favorable exercise of discretion. Now, children of these spouses who are stepchildren of U.S. citizens who also entered without admission or parole will be eligible. Now, if these people are paroled, they'll be able to apply for their green cards without having to leave the United States despite their unlawful entry. So that's excellent news, very great news if the program is allowed to happen. Okay, so the federal register notice that will be published by the end of this summer is the document we're all waiting on to give additional information on the application process for the parole in place. It will give us a required fee and then other key information. So we have to wait for all the details on this process. When the application begins, applications will start being accepted, what forms specifically we would use to apply for the parole and all that. So we're going to, in this video, be talking about documentation to establish continuous presence in the US for at least 10 years since June 17, 2014. Okay, continuous presence means that you've been living here for 10 years, right? So June 17, 2014, all the way through to June 17, 2024, at the very least. You could have come way before. That is fine. The burden is on the applicants to prove that you have the requisite continuous physical presence requirement. And there are several ways several types of document that you can use to establish this burden. And I would usually recommend, for the strongest case type, that you use a combination of evidences like testimony, affidavits, documentary evidence. These all together are usually very sufficient to prove your physical presence for 10 years. So you start gathering things such as rent receipts, school records, dental records, medical records, social security records if you have them. So things like academic transcripts, payroll records, letters from a landlord, letters from your priest, letters from your employer, letters from your co-workers, neighbors, friends, telephone or utility bills, church records, children's birth certificates showing that they were born here in the US, right? So you would be here if you gave birth to children in the US, marriage licenses, and several other documents. So the documents are usually very crucial to prove your 10 years of continuous presence. And ideally you should be able to show proof for each month of each of the 10 years. So you want to start gathering from June 17th, 2014. You go all the way to July 2014, August 2014. Ideally, you could also do documents that you can amass at least for each year. So 10 years. So you have for 2014, 2015, 2016, 2017, all the way to 2024. But each month would be really good evidence. Okay. Now, if you have not kept records, obviously because of your status, some people are just not able to get records, or they cannot find many documents because they've been moving houses, or because of that they were undocumented. They just could not. They don't have a lot of evidence. We will have to explain why you don't have proof of your physical presence. And ideally, even in a case where there's just a few documents, we should be able to prove with credible testimony, letters, testimonies from friends, neighbors, family, to show that, or to verify that you've been in the US for 10 years. So start keeping your records, start organizing them, pulling out all these things. Obviously, a lack of documentation will make your case less strong, but you still should be able to demonstrate that you have physical presence, so long as you have been in the US for the last 10 years. Okay. The next thing we can also do would be to pull up all your US immigration records. So we can pull up your immigration file from immigration court, from the CBP, that's the airport or land border, any port of entry. Then we can also pull up your immigration file, your entire alien file from the USCIS, United States Citizenship and Immigration Services, to see if you've applied for anything in the past. There's just anything that they have on you. We could also we could also request your immigration file from the Department of State, which is U.S. embassies, or the U.S. embassy where you've ever filed any visa application. I mean, obviously for this process, the people who are applying their last entry into the U.S., they did not come in with a visa, but perhaps you have filed something. Maybe you filed an application and it was denied. We want to pull up all those things and, start reviewing them. And it takes time for the government to release these records to us, because usually it depends on the complexity of the records that you are looking for. They have to go into their archives and locate the exact records, and then obviously you'll be placed in a queue once you request those records. So there's a lot of wait time once you file the request of these records in order for the records to be released to us. So you want to get started on that early. Okay, so I hope this video helps you start digging through all your old documents, and if you need help, don't hesitate to contact us 802-780-0564. I can't wait to speak with you. Bye.